Today is Tuesday, June the 9th, 2015. The time is 10 a.m. It's my pleasure to call the order of the State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosley, will you please call the roll?
Mark Cawthorn.
Here.
Robert Helms.
Here.
David Neal.
Here.
W.T. Patterson.
Here.
Jane Gray Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor.
Here.
Mr. President, we have all board members here.
Thank you, Ms. Mosley. We have a quorum. We'll continue with the meeting as planned. Next, we will review and adopt the agenda for the meeting.
I move to adopt the agenda as presented.
Second.
Have a motion from Ms. Sowell and a second from Mr. Neal. All in favor?
Aye.
Next on the agenda, motion carries. Next on the agenda, we'll have a review of our minutes, which are before you there from the May 12th meeting.
Move to approve the minutes as
Second.
presented.
I have a motion from Ms. Sowell and a second from Mr. Helms. All in favor?
Aye.
Minutes are approved. Our formal hearing, which was scheduled for today, has been postponed to the September meeting. Their attorney has asked for an extension, which was granted. Next, we'll have our legal report from Ellery Richardson, our Assistant General Counsel.
The first case on the report is case number 2014-031-601 and 2014-031-602. Funeral establishment filed a complaint against respondents for unprofessional soliciting business. Respondents have also told many people that complainant funeral establishment is closing. An investigation revealed evidence that respondent funeral director passed out business cards and calendars during 3 services or visitations at various churches. 2 of these were conducted by the respondent and 1 was conducted by the complainant. Respondent denies the allegations in full and states that he has done work with the complainant in the past and complainant owes him a substantial amount of money. The statute in contention is TCA 625317B3, which prohibits solicitation after death or when death is imminent. So my recommendation would be to close as the solicitation did not occur after death or when death is imminent.
Motion to accept. Second.
I have a motion from Mr. Helms, a second from Mr. Cochran. All in favor?
Aye.
Motion carries.
Case is case number 2014-03145. Complainant states that his father passed away on October 26th. Respondent kept calling and asking him to hurry up and put him in the ground while complainant was contemplating the arrangements. When complainant did make the final arrangements, he states that respondent did not give him a price list, nor did he see one anywhere. Instead, respondent led him into a room full of caskets and told him that this is what he, complainant's father, would like. Respondent never asked what his monetary limits were. Respondent did not give complainant an itemized statement until 19 days after the burial. Complainant did not receive a copy of the insurance policy assignment until December 10th, over a month after the burial. Respondent states that he did contact complainant multiple times by phone because complainant would not come to make arrangements. Respondent states that their price list was available in the family conference room where he met with complainant, and all the caskets in the casket room are labeled with descriptions and price. Respondent states that the bills took a while because they couldn't reach each other by phone. Every time complainant called, respondent manager was on a call, and the staff were not funeral directors and could not have handled the financial arrangements. An investigation revealed that there was a price list on the arrangement conference table, but the table was extremely cluttered, and complainant may not have seen it or thought it was for him unless explicitly shown or given. And the funeral rule requires that consumers are given a copy of the general price list to keep. The statement of funeral goods and services selected was dated November 5th, 2014. However, the arrangements were made on November 4th, and the burial was on November 6th. So the investigation revealed several funeral rule violations. That'd be the price list not given, the statement of funeral goods and services dated 21 days after the arrangements were made, and not giving copies of documents at the time of the arrangement and obtaining the signatures. So my recommendation would be a consent order with a civil penalty of $1,000, investigation costs of $425, and authorization for a hearing.
Move to approve the recommendation of council.
Second.
I have a motion from Ms. Sal and a second from Mr. Neal. All in favor?
Aye.
Recommendation carries.
Next case is case number 2015-003781. Complainant received letters from the insurance company stating that they haven't paid their premiums. Complainant paid the premiums to the funeral home every month and has not missed. She called Respondent Funeral Home and they said the insurance company is wrong and not to worry about it. The letters kept coming, so she called the insurance company and they state that they haven't received the payments and she needs to talk to the funeral home. She has receipts for years saying they've paid the premiums to the funeral home, but her policy was changed to a loan because of the missed payments. When complainant compared her receipts to the pre-need policy, she discovered she's overpaid by $19.20. Respondent states that all they do is forward the premiums, and they do this because the prior owners did this, so they continued it as a courtesy to the customers. They have documentation that although complainant has paid every month since 2000, there were 3 years where they did not make any payments and instead paid a lump sum in the year 2000. Those late payments turned her policy into a loan. Respondent states that he has no control over that or the overpayment. The insurance company should have declined the overpayment. They merely forward the checks on. And it does appear the policy changed to a loan back in 1997. My recommendation would be to close the complaint.
It says there were 3 years where they did not make any payments.
That was the complainant.
Who, the complainant is,
Yes, there were a lot of records that were presented as part of this complaint, and there is documentation that they have paid every month, occasionally on time, occasionally late, but they have paid every month recently, past several years, but there was a 3-year gap back in the 90s. That's when the policy
into a
lapsed.
loan.
Mm-hmm.
That was done by a previous owner.
The previous owner of the establishment just forwarded the premiums on whenever they received them. So it appears that the complainant was the one that did not pay during those 3 years back in the 90s.
move approval of recommendation.
Second.
Have a motion from Ms. Sal, a second from Mr. Neal. All in favor?
Aye.
Motion carries.
Next case is case number 2015-002111. Complainant Monument Company states that respondent owes $3,971.35 on monuments ordered from 2011 through 2013. Respondent states that he used to be a salesman for the monument company and that this complaint should not have been filed against his funeral establishment. Complainant states that the whole arrangement went through the funeral establishment. Respondent states that he does have an outstanding bill with the company, and it goes back to 2011 due to an agreement they had that allowed him to pay it back over several years. This agreement ended when he stopped working for them. Since he stopped working for them, the monument company has not contacted him to settle the amount, but instead filed the complaint. Respondent states that the amount owed is only $3,179.60, not the $3,971.35. Respondent stated that he would pay it all by March 31st, but this has not been done. The rule violation would be Rule 0660-11-.051B. Establishments shall honor financial obligations to suppliers, distributors, or other persons with whom they conduct business in a timely manner. So my recommendation would be a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Have a motion from Ms. Taylor, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Case is case number 2015-007291. Inspection revealed two funeral rule violations. There is an $800 discrepancy between the display room and the price list for one casket, and one contract did not have the required itemization of charges by leaving out the price of an outer burial container. Respondent states that they refunded the $800 overcharge to the customer and now have a procedure in place to check prices more stringently. And this has been the third. They have a history of funeral rule violations, and so therefore my recommendation would be a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Mr. Helms, a second from Mr. Patterson and Ms. Taylor. All in favor?
Aye.
Motion carries.
The next case is case number 2015-007311. Managers' licenses were not available for inspection. A respondent did not have a copy of the latest inspection of the crematory used until it was faxed over during the inspection. Respondent states that the licenses and inspection are now all posted. Respondent states that the information was at their other location and was not properly transferred. They also have a history of documentation violations, so my recommendation would be a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Mr. Helms, second from Mr. Neal. All in favor?
Aye.
Motion carries.
Next case is case number 2015-007321. Respondent failed to update its manager for about 7 months. Additionally, respondent's main website lists a location that does not exist. Respondent apologizes and states that both are now corrected. My recommendation would be a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Have a motion from Ms. Taylor, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
Next case is case number 2015-007331. Respondent did not have a copy of the crematory license and inspection report until the end of the inspection. Additionally, respondent's statement of funeral goods and services did not have the required disclosures. Respondent shows that it has corrected the violations. Since there is no history, my recommendation for this case would be to close with a letter of warning.
Motion to accept.
Second.
Have a motion from Mr. Cochran and a second from Ms. Taylor. All in favor?
Aye.
Motion carries.
Next case is case number 2015-007471. Respondent had 2 price list violations for one contract, a failure to itemize, and an overcharge. Respondent refunded the customer the $1,175.04 inadvertently charged. My recommendation would be a consent order with a civil penalty of $500 and authorization for a hearing.
Was there any response to this?
Yes, and they did show proof that they had refunded the customer as part of their response.
Have a motion from Mr. Patterson, a second from Ms. Taylor. All in favor?
Aye.
Motion carries.
Next case is case number 2015-007691. Respondent's establishment license expired on October 31st and was not renewed until November 22nd. During this time, respondent handled 8 cases. Respondent apologizes for the oversight. My recommendation would be a consent order with a civil penalty of $400 and authorization for a hearing.
Motion we accept.
Second.
Have a motion from Mr. Neal and a second from Mr. Helms. All in favor?
Aye.
Motion carries.
The next case is case number 2015-008411. Complainant states that respondent's website directs the public to the Better Business Bureau website, even though respondent is not BBB accredited. Complainant alleges this is misleading and dishonest, leading the public to think that respondent is accredited. The BBB website also lists the owner as the prior owner, not the current owner. Respondent states that they do not take place in the BBB system, but they provide the link for interested consumers. Upon the filing of this complaint, respondent called BBB and updated the owner information. The BBB does, however, still list the former owner. The BBB's website gives respondent an A+ rating. However, it does conspicuously state above this rating that respondent is not BBB accredited. My recommendation would be to close.
Give them an A+ rating if they're not accredited?
There is a whole little paragraph explaining why they do that, right above the rating, saying this
They
is.
don't check on anything. That's why we don't do it anymore.
That's just how they do it, I guess, because they've had no complaints. But it does say that they are not accredited along with the rating.
I'll make a motion to accept. Second.
Have a motion from Mr. Cochran and a second from Mr. Neal. All in favor?
Aye.
Motion carries.
Next case is case number 2015-008741. Complainant attended her nephew's funeral in September and asked for a copy of the DVD that they were playing. Respondent stated that it would take a few days and it would cost $10 to mail, and complainant stated that was fine. Complainant called in the following months and stated that they would put, and respondent stated that they would put the DVD in the next day every single time. Complainant finally received a copy of the DVD in May. Respondent apologized for the delay in sending the DVD, stating that he thought the secretary handled it and she thought the manager had. Respondent states that the DVD was finally sent, and that was confirmed with the complainant. They did receive the DVD. So therefore, my recommendation would be to close.
Motion to accept.
Second.
Have a motion from Ms. Taylor, a second from Mr. Helms. All in favor?
Aye.
Motion carries.
It's case number 2015-008781. Respondent's casket price list is inconsistent from the general price list in 2 places, and respondent did not respond to the complaint. So my recommendation would be a consent order with a civil penalty of $500 and authorization for a hearing.
Accept.
Second.
Was the not responding included in this?
Have a motion from Ms. Taylor, a second from motion from Ms. Sow, second from Ms. Taylor. All in favor?
Aye.
Motion carries.
The next case is case number 2015-009171. Complainant states that she was not allowed to be involved in the arrangements of her mother, but her sister still insists on her helping pay. Complainant has not received any itemized list or amount of insurance available. Complainant also states that she was not at the visitation because the funeral home gave her conflicting information about the time. Respondent states that the deceased took out a guaranteed pre-need for all funeral expenses, but she subsequently moved to Georgia. Transportation costs from Georgia were the only thing not included in the pre-need. The deceased children split the transportation costs among themselves. Respondent never billed complainant. Respondent states that since the deceased already had a pre-need contract, there were no arrangement decisions to be made. and complainant was not kept out intentionally. Complainant never contacted them about any concerns, never requested to review the statement of funeral goods and services, and never had any questions about charges. My recommendation would be to close.
Move to accept the recommendation of council.
Second.
I have a motion from Ms. Sal, a second from Mr. Neal. All in favor?
Aye.
Motion carries.
Case number 2015-009-221. Complaint alleges that respondent provided and charged for services complainant expressly declined because of their cost. Respondent also agreed to look into whether an insurance policy was still active, but respondent never confirmed with complainant whether it was or not. When they spoke by phone, respondent was very rude and hung up on her. Complainant believed after the arrangement conference that the total cost would be around $6,000. The final bill presented was $9,828.08. After a delay of 4 months, the insurance policy paid the total bill and gave complainant the excess, which was $275.86. The complainant additionally states that the signature on the statement of funeral goods and services is not hers. Respondent denies any forgery of complainant's signature and states that all the services complainant mentioned were either not provided or provided at no additional cost. A review of the statement of funeral goods and services and the insurance assignment shows that the amount of $9,828.08 was agreed to and signed by all parties on the day of the arrangement conference. The signature appears to match all the other signatures of complainant in the file. Therefore, my recommendation would be to close.
Move to accept recommendation of council.
Second.
Have a motion from Ms. Sal, a second from Mr. Neal. All in favor?
Aye.
Motion carries.
Next case is case number 2015-010501. Respondent's website lists its staff and does not state that any of its staff are licensed funeral directors. Respondent states that since they just opened in March, their website is still under construction, and their managing funeral director was not yet on the website because they had not obtained his photo and bio. Respondent immediately corrected this and also added a note to each staff member stating whether they are licensed or not. My recommendation would be to close the letter of warning.
Motion to accept.
Second.
Have a motion from Mr. Helms, a second from Ms. Taylor. All in favor?
Aye.
Motion carries.
Right. The last case on the report is case number 2015-009271 and 2015-009272. The Funeral Board received information from the International Conference of Funeral Services Examining Boards that respondent shared NBE exam questions with others. Respondent admitted to sharing his study guide, which included NBE questions with others. The conference subsequently invalidated all of his scores. My recommendation would be revocation and authorization for a hearing, as his exam scores are no longer valid and he does not meet the minimum requirements of licensure.
What kind of study guide? I mean, notes that he took himself, or is this some sort of? Yeah. Does that make sense? I mean, yeah.
It's like a comprehensive or something.
Buy it.
Okay.
Study for the board.
Gotcha.
Yeah, he I'm trying to remember exactly. He created it himself from multiple sources, but he had also taken the test multiple times, and he had some of those questions that he had seen and remembered, like verbatim on the study guide, and that was the issue.
Motion to accept.
Have a motion from Mr. Helms, second from Mr. Patterson. All in favor?
Aye.
Motion carries.
That is the end of my legal report.
Next will be administrative matters. Mr. Robert Gribble, Executive Director.
Mr. President, first we have the licensee report. The report of license administratively approved by the Executive Director pursuant to the Board's authority for the period of May 12, 2015 through June 8, 2015. and you have those before you. Most of them this month are establishments. Just for clarification, the second one listed there, Ellis Funeral Home and Cremation Service, Grandview Avenue location, that's actually their crematory. They have another license in the same name, which is their funeral home, but they've added a crematory and licensed it separately under the same name as the funeral home. Closed establishment report. There's one establishment reported closing since the last board meeting. That's Lakeview Funeral Home and Cremation Service located at 182 West Main Street in Hendersonville, Tennessee. It's the old location that was there in Hendersonville. Action report is a report of consent orders administratively accepted and approved by the Executive Director pursuant to Board authority for the period of May 1, 2015 through May 31, 2015. Last person listed on there is that individual failed to pay child support or to be compliant with his child support arrangements. So from time to time we get notices from the where someone fails to pay child support, compliant with their child support arrangements, and also with their student loans. And we're required to immediately suspend those licenses, and we cannot reinstate them until we get official notification from the agency that sent it to. Sometimes people get upset about that. They don't like it. The letter that goes to them when their license is suspended is very clear. It's like a 3-page letter and lays everything out step by step. Lets them know who they need to contact, what they need to do, and that we're automatically required to suspend them, and we cannot reinstate them. But still, usually we get the blame over it because they got suspended. Open complaint report. As of yesterday, there were 47 complaints open in the Board of Funeral Directors and Embalmers. 1 of those against an apprentice, 8 against funeral director and/or embalmers, and 38 against establishments. And also, I want to report 2 other things to you. I think this board will recall a hearing that you had in April, Snow Funeral Home, and you set out in that conclusion of that hearing specific actions that party should take in order to continue to have a funeral establishment license. And one of those was that they'd be given until the end of May the 31st, to have a facility that met the minimum standards for a funeral establishment. Our field representative went and did an inspection on Monday, June the 1st, which would be not yesterday, but the week before. And based on the report, based on the board's order, and based on the photographs that were contained in the report, we suspended their license last week for an indefinite period of time. Mr. Richardson has been in communication with Mr. Chairs. Mr. Chairs sent another photo. Well, obviously the field rep made photos, and we have those in her file. And then Mr. Chairs sent another photo on Friday evening late to Ms. Richardson, and we reviewed that, and she sent him an email back letting him know the list of items that he needs to come in compliance with. So, doing what the board directed us to do, but we just want to report to you so that you're aware of it. Also, last week, and let me say up front, I've not got a chance yet to talk to Bob Batson, who is the executive director of the Tennessee Funeral Directors Association, about this. I was on vacation last week, and he's at the convention this week, and I knew he was real busy, so I didn't try to call him, but I will follow up with him. There was a Tennessee Funeral Directors Association sent out an email cautioning their members about going into other states and doing removals and conducting funerals and things of that nature without having the proper authorization. And Miss Sal contacted me by email and asked me, she says this is what the email talks about, getting a courtesy card from the state of Kentucky, but it doesn't say how to do that, and asked me if I would check on that, and I responded to her and told her I'd be glad to do that and get back in touch. So yesterday, the executive director for the Kentucky State Board of Embalmers and Funeral Directors, my counterpart in Kentucky, she and I had a conversation on the phone, and she confirmed what I thought. Kentucky will not issue a courtesy card to Tennessee residents. Now, she told me yesterday, in their mail yesterday, that she'd gotten 13 applications and 13 checks that she would be returning back to people.
Of it being available if you can't get one.
Well, the history to it is back was when Mr. Eugene Williams was president. That's been about 5 or 6 years ago. Mr. Eugene attended 2 meetings. They had meetings I think they were in Cincinnati, if I recall correctly, where Ohio, Kentucky, another state or two, and they invited Tennessee to participate. And Eugene came back and reported to the board at that time that basically you bought into what they wanted to do. It was all or nothing. They were not negotiable in how they wanted to do this. So the board elected not to participate because it would have taken a statute change. It would have taken legislation to be able to have been able to change it. And the board thought the best thing to do was to keep it like we got it. We issue a license to any state by reciprocity. You know, if the person has a minimum requirements in another state and they're licensed, then we'll issue them a license in Tennessee through reciprocity. Because had the board agreed to do what Kentucky and Ohio and I can't remember the other state or two wanted to do, then that had a lot of implications about what we did with Alabama, Mississippi, and all the Georgia and all the other border states. And Mr. Eugene said he recommended the board not to do it, and from all the information I gotten and read about it, then that appeared to be the best thing too, is not to participate in it and do it. But this email that was sent out last week has caused a lot of confusion because not only did Kentucky get 13 applications with checks for $75 each in their mail yesterday, and she assumed they would probably receive more today and in subsequent days. Last week and yesterday, we also got applications sent to us where they wanted us to certify their license so they could send them on to Kentucky. Well, there's a fee to certify their license, and we don't want to contact them back and tell them to pay the fee for the certification, and then they pay us for the certification, send it to Kentucky, and not be able to get the courtesy card. Now, back at the time, and again yesterday, I think that Kentucky is very harsh on the Tennessee license in this way. Kentucky maintains that if you have I'm talking about the Kentucky State Board, and I've spoken to Mr. Danny Purcell about it previously. I didn't speak with him yesterday, but I've spoken with him previously. He's the president of the board there. But they maintain that if you have a Kentucky funeral director license, in order to come into their state and make a removal of a deceased remains, then you also have to be affiliated, and I'm not sure how they define affiliated, if it has to be a bona fide employee or not, of a Kentucky funeral establishment. So take me, for instance, and some of you folks may have a Kentucky license. Well, but if I were working in the private sector, I have a Kentucky funeral director and embalmer's license. And I was telling Ms. Chandler yesterday, I think it's discriminatory. Because if I have a license to practice in their state, then they're putting the added phrase to it that I have to be affiliated or employed by one of the Kentucky firms in order to come over there and make a removal. But yet, they'll issue a courtesy card to someone in Ohio that doesn't have a license at all. It's just a courtesy card, and let them come in and make a removal. And she agrees, but she said the board doesn't agree, that they interpret that, So I don't know, it's frustrating.
Some people heavily fined. Haven't there been some
I've been told there is. I don't know, but I've been told
heavily
that there is.
fined for going into Kentucky and making a remove, simply making a remove?
And Tennessee, of course, will allow anyone to come in at the present time and make a removal, whether they're licensed or unlicensed. Now, obviously, if it's a transportation service or a transport service, then they should be registered as a removal service with the board. Since that law was passed a couple of years ago, they should be, removal service. It's, I don't know, at one time there was some discussion that maybe the Funeral Directors Association was going to try to get legislation passed to where in order to file a death certificate in Tennessee, you had to be a licensed funeral establishment in Tennessee. So I don't know. That may be I don't know what the reason for this email was, so I don't need to speculate. So, just for your information, from time to time, and we don't harass anyone, we don't focus on any state, but from time to time, our field representatives do check borderline counties or counties that are borderline to other states to see if the people coming in Tennessee have a funeral director and embalmer's license. Well, if they're doing embalming, they need an embalmer's license, but usually it's a funeral director's license because they're usually conducting a funeral service at a church or a graveside in the state of Tennessee, and maybe coming from Alabama, Georgia, Kentucky, Mississippi, or wherever they might, Ohio, New York, Pennsylvania, wherever. So from time to time, we do check that, and like I say, we don't focus on any particular state. And the board's taken disciplinary action against firms in multiple states for not having a Tennessee license and being in Tennessee conducted a lot. So I guess we'll just see what the rest of the story is.
Don't their board operate, aren't you kind of appointed up there till death or something? Some kind of they don't change very much.
They don't, it's
kind
unlike
of a
Tennessee.
good
It's not
buddies.
for, it may be for,
Motel.
Yeah, they're a good buddy system, I think.
it's kind of like a federal judge, I think. You're appointed for, you may be for a period of time, but you can be reappointed, I guess, unlike what Tennessee is. Like I say, I've talked to Mr. Purcell directly about this before. He's very committed to his position and very unwavering about it.
So just for clarification, you're saying that Ohio can ask for a card,
Courtesy card.
courtesy card, but Tennessee can't.
Yes.
You can ask, but you're not gonna get it.
So they like Ohio better than they do Tennessee.
Well, they do not like it because Tennessee didn't participate in their PAC agreement, I guess. I think that's what we're being punished for, is because we chose to not participate in their agreement that they wanted to do. I can't think of what other state. Seemed like there were 4 or 5 states, and but I know it was Ohio, Tennessee, and Kentucky.
Anna, maybe.
It probably was Indiana, but it just
Oh, 'cause see, they're right there, like Indiana and Cincinnati and all, they're all right in there together, just across the river, and they need to be where they can do it.
if you know any individual board members that serve on the board in Kentucky, you might individually, if you have an opinion about it, you might want to contact them and express your opinion. End of the day, what I think is wrong is if someone from Tennessee has a Kentucky funeral director's license, that they will not let them come in and make a removal unless they're employed by or affiliated with a Kentucky funeral establishment.
What about conducting a funeral over there? We got several guys that are licensed. We send them into Kentucky.
Oh, Bob.
Got a license, that I don't know what else you can,
I would encourage you, Mr. President, to contact the Kentucky board and ask them directly, because my understanding is like Ms. Sal says, that they've assessed some like $5,000 civil penalties. So it's not a $500, but it's got another zero at the end of it. It's $5,000 is what I've been told.
We've been told that the only way we can make a removal is it has to be a licensed funeral director in Kentucky to make the actual removal before we can get the individual.
that's what we've,
I think most people that know about it comply with it. It's when someone does it not knowing about it, and then they receive the civil penalties later. But anyway, I wanted to make the board aware of it. I will follow up with Mr. Batson later and talk with him, and I will also, we're intending to send a memo to each one of these people who sent us a Kentucky application to certify, just basically to give them some information to tell them that, that having talked to their executive director, she confirmed that they're not going to issue the courtesy card, so we don't want to charge them for certifying their license when in the end of the day they're not going to be able to obtain the courtesy card.
they can give a courtesy card to whoever they want to.
I I don't know. She said that they wouldn't give one to Tennessee, is what she told me yesterday.
Do they have, is that in their policy, written policy, that they will not issue one to a Tennessee licensed licensee?
I don't know myself whether it is or not, but she verbally told me that yesterday.
I think that could be challenged. That's purely discriminatory.
Purpose of having a Kentucky license.
And we have several people in Tennessee that do have a Kentucky license, especially on the northern border,
Same
because
thing
Tennessee
with
is.
Alabama, a lot
Yeah.
of people at Georgia.
Mr. Neal's got an Alabama license, don't you? Different.
Kentucky hasn't come back and said you have to work 40 hours a week in Kentucky before we renew your license, or else your license will be suspended or whatever until you work the 40 hours a week in the Kentucky funeral home or establishment.
They won't do that because they want the money.
Money, but you can't use what the money's for.
I sent my renewal in to them yesterday, put in the mail yesterday, and one of the things that they do require now is part of your continuing education has to be in person, live, face to face, in front of someone. Half of it does. You're required to have 12 hours of continuing education every 2
You
years.
have to do it in Kentucky.
No, so far they haven't. It has to be a Kentucky approved class or one that was approved. The one that I took was approved through a national organization. So
Have you couldn't, or can you rather, take a continuing education course and have your be given credit in Tennessee and Kentucky for taking that course?
I think so, but I mean that would be a call by the Kentucky. I mean, what we
See how
require.
they can, if you did it, if it was valid for Tennessee CEU credits, valid for Kentucky
As
CEU.
far as I know, it is if you're a Tennessee resident. As far as I know, that they will allow that. And that's what we do if we have an out-of-state resident that is licensed by this board, then we accept the CE from that state. But now, if you're a Tennessee resident, you're required to take courses that have been approved by the Tennessee board. But if you're an out-of-state resident, then we'll accept the courses that, like if a Kentucky resident has courses that have been approved by the Kentucky board, then we accept those, and all the other states tend to do that likewise. Yeah. But Mr. President, that concludes my report.
Gribble?
Motion, we accept it.
Have a motion from Mr.
Second.
Neal, second from Ms. Taylor. All in favor?
Aye.
Next will be a legislative update from Mr. Gribble. And
As you probably aware, the legislature is adjourned, and last month we had the updates as far as the bills that were passed and things like that. For the people that have signed up for Notify, they will be receiving a notification through that email process as to how these new laws will affect them. And so I would suggest to any person that's, whether they're licensed or not licensed, to go on their website and do the Notify, Notify, and you sign up for the funeral side, and you can also sign up for the burial services, and that way you receive notifications about pertinent matters. You won't be receiving an email each day, and you won't be receiving one each week, but you will be notified about rulemaking hearings, proposed licensing changes, new legislation that's passed, and things of that nature. So that will be done in the next few weeks. Ms. Richardson's already gotten the information that the board's required to have to the proper people for that to be sent out after it's reviewed. So that concludes the legislative report, unless someone has some questions. We probably need a motion to accept it, even though it's
Move
really
to
not
accept.
not a very detailed report.
Second.
have a motion from Ms. Sow and a second from Mr. Helms. All in favor?
Aye.
Next will be approval of license applications.
There are none this
None?
month to appear before the board, Mr. President.
All right. Thank you, Mr. Gribble. Is there any new business to come before the board? Not being any new business, we'll ask for a motion for adjournment.
Moved.
Second.
Have a motion from Ms. Taylor and a second from Mr. Cochran. All in favor?
Aye.
Meeting is adjourned.